The next bill on the calendar for the day is House File 9. The clerk will report the bill.
House File number 9, number 2 on the calendar for the day, an act relating to public safety, enabling law enforcement and family members to petition a court to prohibit people from possessing firearms if they pose a significant danger to themselves or others.
I recognize the member from Dakota, Representative Richardson, the author of the bill, to explain the bill.
Thank you, Madam Speaker. Members, Minnesotans deserve to be safe in their homes and within their community. House File 9 creates a procedure under which a chief law enforcement officer or deputy or a city or county attorney can petition a judge for an extreme risk protection order. The goal is to keep firearms out of the hands of people who are at risk of self-harm or who pose a danger to others. There are already 13 categories of people ineligible to possess firearms in state statute. This bill adds a 14th category. Red flag laws are not new. The sad history of red flag laws is that they are often enacted after horrific tragedies. The first law was enacted over 20 years ago after a tragedy in Connecticut, where 4 state lottery workers were shot and killed. More recently, Florida passed a red flag law after 17 people were killed and 17 others were injured. 17 states and the District of Columbia have enacted red flag laws. Red flag laws have been passed in both Democratic and Republican-controlled majorities, and red flag laws have also saved lives by creating a mechanism to act when warning signs are clearly there before it can escalate into a tragedy. It's important to recognize here in Minnesota that we are facing a public health crisis. 4 out of 5 gun deaths in Minnesota are suicides. And when you think about 4 out of 5 deaths being people at risk of self-harm, we know that we have the opportunity to save lives. And in the 17 other states that have passed red flag laws, they can point to lives that have been saved. With that, Madam Speaker, if we could move on to amendments.
There's an amendment at the desk. The clerk will report the amendment.
Nash moves to amend House File number 9, the first engrossment as follows. The amendment is coded A26.
The member from Carver, Representative Nash.
Thank you, Madam Speaker. And there is an amendment to the amendment as well.
Would you like to explain the amendment at all?
Yes, Madam Speaker. The amendment is to, and there's if the pages would pass out something as it comes to your desk. The A26 would require law enforcement agencies to take due care of firearms received under this section to ensure that firearms are not damaged. And I'll speak a little bit while the pages are getting that. Many folks who may fall prey to a red flag seizure are owners of very fine and valuable firearms. It is my concern, and I've expressed this to the author in committee and to others, that if law enforcement agencies do not have the ability or do not take due care, that those items will be returned to the individual, if ever, in a damaged state. So that is the A26, Madam Speaker.
There is an amendment to the amendment. The clerk will report the amendment.
Nash moves to amend his amendment to House File number 9, the first engrossment. The amendment to the amendment is coded A28.
Representative Nash.
Thank you, Madam Speaker. To further that, this says that law enforcement agencies will have to be liable for what happens potentially damaging to the items that they are entrusted with under red flag seizures. And Madam Speaker, I've spoken to a good number of sheriffs, police, and what you'll see in the picture that's being passed out to you is from the Star Tribune. It is a picture of the Minneapolis Police Department's evidence room. And that's Obviously, they are not taking due care, but during the conversation, I actually had hoped that Representative Novotny might yield to a question to accentuate the need for this amendment, Madam Speaker.
He will yield. Representative Nash.
Thank you, Madam Speaker. Representative Novotny, you're a police officer, and I would appreciate it if you could tell us what many evidence rooms are like, and if you feel, as a current serving police officer, if you feel that the evidence rooms are sufficiently designed to take on a good number of these guns that will be seized and put into the evidence locker.
The member from Sherburne, Representative Novotny.
Thank you, Representative Nash. I am a member of the Sheriff's Office, and I'm a Sheriff's Deputy, currently a Patrol Sergeant. Previously, I was the supervisor of the evidence room, and in that capacity, we would have one of the responsibilities would be that after a firearm that had been seized as a result of a crime or for other reasons needed to be destroyed, we would take that firearm out of evidence, and in our evidence room, it was in climate-controlled conditions and boxed up. Some of these firearms are 4, 5, 6 years before they are cleared for disposal. A firearm in a climate-controlled box condition very often would have a condition of almost being destroyed. A simple sweaty palm print on a gun left for 4 or 5 years unattended will destroy that classic gun. It also creates storage problems. As Representative Pinto pointed out earlier in discussion on the previous bill, when you get to the rural departments, they just don't have the capacity or the storage capabilities to be able to properly store these weapons. And I've been in that vault at the Minneapolis evidence room, and that is an accurate representation of the conditions that are there.
Representative Nash.
Well, thank you, Madam Speaker, and thank you, Representative Novotny. That's exactly the case that I've been making for a very long time. Under this bill, and Representative O'Neill will point out some of the many, many deficiencies, but if somebody were to, I'll just use myself as an example, if somebody were to issue a red flag warning against me and I were deprived of my Second, Fourth, and Fifth Amendment rights and my guns were taken, I have a couple that are really quite valuable, and I have grave concerns that if put into evidence, they would come back relatively worthless. So that is my amendment, Madam Speaker, and I would request a roll call.
Representative Nash requests a roll call. Seeing 15 hands, there will be a roll call. Discussion to the amendment. Representative Richardson.
Thank you, Madam Speaker. Thank you, Representative Nash, for bringing forward this amendment. I understand the goal of ensuring that people's property is protected, and that's why within the bill, Section 9 of the bill, thinking about the liability for the protection of firearms, we would ensure that, we'd want to ensure that with law enforcement that they're not doing anything intentionally to be reckless or intentional misconduct or gross negligence. And so with that, if they were to act in a reckless way, they would not be immune. So I would ask for a no vote from members.
Discussion. Representative Nash.
Well, thank you, Madam Speaker. And to the author, well, that's not really getting at the issue. You heard from Representative Novotny that a single fingerprint on a firearm stored in evidence can and will create rust on a firearm and put it in a shape that is really creating a worthless gun. And for those of us that have some fine firearms that have great value, if that were to happen, if I were to be deprived of my Second, Fourth, and Fifth Amendment rights under your bill, and some of my guns were taken away, they're going to come back worthless. So what you just said isn't what I'm trying to get at. So, members, I would urge a green vote. Thank you.
Seeing no further discussion, the clerk will take the roll on the amendment to the amendment. The clerk will close the roll. There being 58 ayes and 72 nays, the motion does not prevail. The amendment to the amendment is not adopted. There is another amendment to the amendment. The clerk will report the amendment.
O'Neill moves to amend the Nash Amendment to House File Number 9, the first engrossment. The amendment to the amendment is A29.
The member from Wright, Representative O'Neill, to your amendment to the amendment.
Thank you, Madam Speaker. Along the same lines as what are the responsibilities for law enforcement, this amendment would assure that when law enforcement arrives on the scene and they are concerned about someone's safety, so much so that they are actually issuing this order, then instead of just taking the guns, it would actually be required to take them on a 72-hour hold. Because if they are truly in danger to themselves or others, this is the only responsible step we could possibly take. We should not be leaving someone who is in crisis alone in their home. Yes, we took the weapons, the guns, but there are other things in their home that could also, they could cause self-injury or injury to others. And so that is what this amendment is. And I would ask for a roll call, Madam Speaker.
Representative O'Neill requests a roll call. Seeing 15 hands, there will be a roll call. Representative Becker-Finn.
Madam Speaker, point of order.
State your point of order.
Point of order under 3.21B, an amendment to an amendment on the House floor must relate only to the primary amendment without introducing any new subject. The underlying amendment here is about storage of guns. This A29 amendment brings in an entire different area of statute, which would be the civil commitment statutes.
Advice. Representative O'Neill.
Thank you, Madam Speaker and members. So this is still about the responsibilities of law enforcement. Yes, they have different levels of responsibility, but this is still in the same issue area as what their responsibilities are. And I would ask you to.
Having reviewed the point of order, the rule 3.21B, the amendment to the amendment and the amendment, I find the point of order is well taken.
I would
the
like
amendment,
to challenge the ruling of the Speaker.
Representative O'Neill challenges the ruling of the Speaker and requests a roll call. Seeing 15 hands, there will be a roll call. Advice to the body. Anyone? All right, seeing no advice to the body. The question before the body is, shall the decision of the Speaker stand as the judgment of the House? A yes or a green vote supports the ruling of the Speaker. A no or a red vote goes against the ruling of the Speaker. The clerk will take the roll. The clerk will close the roll. There being 73 ayes and 57 nays, it is the judgment of the House that the decision of the Speaker shall stand. To the Nash A26 amendment.
Well, thank you, Madam Speaker. And folks, take note. Everybody says, oh, we'd be open to your amendments, but clearly, not so much. I think I'm just going to withdraw this amendment.
Representative Nash withdraws his amendment. There's an amendment at the desk. The clerk will report the amendment.
Lucero moves to amend House File Number 9, the first engrossment. The amendment is coded A27.
The member from Wright, Representative Lucero, to your amendment.
Thank you, Madam Speaker. My amendment is rather simple, common sense, and pro-Minnesotan. And it's so small, I'm just going to read it, Madam Speaker. A respondent is entitled to effective assistance of counsel. The court shall appoint counsel to represent the respondent at no cost to the respondent. So, Madam Speaker and members, this bill before us, House File 9, is simply a violation of due process. It's a violation of multiple constitutional protections, as Representative Nash enumerated. And we have a decades-long precedence in Minnesota that if your rights are deprived of you or from you, and you don't have the ability to afford counsel to represent your interests, that you're afforded counsel at no cost to you. And so this amendment, Madam Speaker and members, seeks to ensure that after somebody has been deprived of their constitutional rights in this process of having to prove themselves innocent after first been accused of being guilty, that they would be able to have counsel and representation in their battle to maintain their constitutional rights and get their firearms back. So having a right to a lawyer is not something new. Now, I understand that this process is under a civil matter, under the umbrella of a civil matter, but it involves constitutional liberties, and therefore it's not simply a civil matter. We need to protect Minnesotans' civil rights, and that's why this is important. And members, in the absence of this, Madam Speaker, and members, if you vote this down and you don't allow people to have representation, that's going to create disparities. Where will these disparities manifest themselves? By those who can't afford. The poor, maybe single moms who are working multiple jobs, minorities who can't afford to hire a lawyer to represent them in their battle to get their firearms back. So members, my amendment is pro-minority, pro-women, pro-poor, to give them the assistance to put them on an equal footing as those who can afford a lawyer to represent them. So members, Madam Speaker, please vote green. Thank you.
The member from Hennepin, Representative Carlson.
Madam Speaker, Rule 4.05, if an amendment would increase the cost of the bill, it is out of order. And I think we all know that whether an attorney is in the private sector or a public defender, that does cost, and that would be my advice, that the amendment would increase the cost of the bill.
Representative Carlson rises to a point of order under Rule 4.05, advice. Representative Lucero.
Madam Speaker, what we just heard was that it'll cost money. That's right, it will cost money, Madam Speaker. But we want to have that cost paid for by the state. And so I would urge you to rule the point of order not well taken.
I have reviewed the point of order and with the advantage of the pre-filing rule. Also had a chance to look at the public defender budget, which is looks like about $200 million over the next biennium. So I do find the point of order well taken.
I would
Representative
appeal.
Lucero.
I would appeal.
Representative Lucero would like to appeal the ruling of the speaker and request a roll call.
Fantastic.
Looks like you have the hands to do it. All right. Representative Lucero requests a roll call. Seeing 15 hands, there will be a roll call. Would anybody else like to give advice? All right. A green vote upholds the ruling of the speaker. A red vote goes against the ruling of the speaker. The clerk will take the roll. The clerk will close the roll. There being 74 ayes and 56 nays, it is the judgment of the House that the ruling of the Speaker shall stand. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File Number 9.
Third reading, House File Number 9. Discussion to the bill. Representative O'Neill.
Thank you, Madam Speaker and members. I thought we'd talk a little bit about the language of the bill. My favorite topic of all time, the policy and the words in the bill. So I know Representative Richardson kind of gave you a synopsis of the bill, but I want to give you a little bit different understanding and maybe a little simpler understanding of what this bill is actually doing. Let's start at the very, very beginning. Now, when this bill first came through our committees, the person that started this entire initiative, the petitioner, was actually a family member, someone that lived with that person, maybe a neighbor, somebody that knew them fairly closely. And now it's changed to law enforcement or prosecutors. So it basically has changed to really anybody can start this process against anyone else because they submit it to law enforcement. Now, law enforcement has to do some sort of investigation and figure out, is it substantiated or not? But let's look at the very beginning and the very base of where this whole process starts. It says that if we think that that person is in danger of inflicting bodily harm on themselves or someone else, then this process can start. Well, let's look at what the definition of bodily harm is. We haven't talked about this yet. Now, one of the definitions of bodily harm is causing someone physical pain. So this entire process could start if I was afraid, if I was in fear that someone was going to step on my toes, kick me in the shins, slap me on the back, grab my arm too hard. That's where this process starts. That's what bodily harm means. Bodily harm does not mean that you caused a bruise. Bodily harm does not mean that you cut somebody. Bodily harm does not mean that you broke someone's arm. It doesn't mean that you pulled a big chunk of their hair out. Bodily harm means you cause somebody physical pain. It's the lowest standard when we talk about assault. So that's where this process starts. So first of all, anybody could launch attacks or accusations against anybody else, and that goes to law enforcement. And the base at which they have to start the investigation is, do we think that this person is a risk to themselves or someone else to cause them physical pain? Now, when you get to court, there's two different options when you get to court. They could either do just a regular order or they could do an emergency order, right? So with your regular order, it could take a month, to be quite honest. When you look at the language of the bill and you go back and forth and it has to be served, and you have so many days, and then you have to have the hearing, and you could have a continuance. By the time you're done with all of that, it could be a month later. So how emergent really is it after a whole month passes? Or, so that's one option, or it could be an emergency order, and then you have an ex parte hearing. Ex parte meaning the person you're accusing doesn't have to show up to the hearing. That's where due process comes in. So if they present enough evidence, let's just look at the list of things that the court considers. Let's look at that list. This is on page 7 if you want to follow along. So let's start with the first thing, a history of threats or acts of violence. So a threat. So you have a history of threats. So you have a history of saying things verbally, okay? That's one thing they consider. The second one, threatened use of force and a few other things. But again, a threat. So again, verbal. You haven't actually touched anybody. Let's go down to number 4. You had a prior arrest for a felony. Not a charge, not a conviction, an arrest of some type of felony. Could be any felony. any felony. And they range greatly. Again, only an arrest. These are things a court is supposed to consider according to the bill. Let's go on. A conviction or, again, a prior arrest of a violent misdemeanor offense. Stalking or domestic violence. Again, an arrest, not a charge, not a conviction. Now, we do have one conviction on the list. There is a conviction, and it is animal cruelty. So if you've been convicted of animal cruelty, that's also something that can be considered. There's also unlawful and reckless display of a firearm. Well, that's kind of up to interpretation, right? I mean, so again, you haven't touched anybody. You haven't laid hands on them according to the things that they're considering. Then you have history of self-harm. So history means you've done it more than once. And I don't see a definition of what self-harm is. So that's problematic. And then it's that you have an existing order like this order that we're looking at right now. So it's a really interesting list. And then really anything else. So then the last thing you have to say too is, you know, it could be really anything else the court would like to consider. That's what we're doing here today, folks. I don't know if you understood, but that's what the words say. We're starting with the level of bodily harm, so we're afraid someone is going to cause us physical pain. Step on my toe, kick me in the shin, slap me on the back. But what the court considers are all kinds of things where there hasn't been a charge and there has not been a conviction, except animal cruelty. Let's look at the civil standard. What does the court have to consider? Is it clear and convincing? I wish there were more lawyers in this room so they knew what that meant. That's about a 75%. So clear and convincing is the highest civil standard. No, it's not that. It's a preponderance of the evidence, which means more likely than not that they will actually cause somebody else or themselves physical pain. And for that, we will send in law enforcement with a search warrant, go through their house, and take all of their guns. That is what this bill does. That is the words on the paper. Let's talk just a little bit about how much time. So once this order has been issued, how much time do you think a person has to turn over the gun? So remember, the first order is, it could take a month by the time you get done with your serving, because there's a whole bunch of different ways to do service. A continuance and other things. But once that order has been issued by the court, how much time do you think that person has to turn over their guns lawfully? Have you read the bill? It's 24 hours. You have 24 hours to lawfully turn your guns over to either an FFL, law enforcement, or a trusted friend, I believe is still in there. Now, the second order, where it's an emergency, and it's ex parte, so you don't even know that it's happening because you're not there. As soon as that order is issued, you also have 24 hours to lawfully turn over your weapons. And also, law enforcement is given the authority to have a search warrant, go into your home, and take them all. Now, here's a problematic thing. What if you have roommates? I asked this question multiple times in committee, and I got no answer. So I'm going to ask Representative Richardson, would you yield?
She will yield. Representative O'Neill.
Thank you, Madam Speaker. Representative Richardson, I kind of explained how these two different paths work, but when law enforcement shows up at their door, say they have roommates. Say they live where my daughter is going to live soon, by Lake Calhoun, and she's going to have 2 roommates. Say you have 3 people living in a home. and one of them there was an order against, but all three of them own guns. What is law enforcement supposed to do?
Representative Richardson.
Thank you, Madam Speaker. Thank you, Representative O'Neill, for the question. In terms of how police can respond, it doesn't necessarily need to be at the home. And in fact, with many of the orders that have been done in many cities, oftentimes it's not necessarily them going to the home. So there are different ways that the guns can be transferred. And I would also add, with the history of red flag laws, because we have a 20-year history, there is information about how roommates have been dealt with within other cities, and that there are processes that have been put in place to determine ownership of guns, to determine whether a gun would be subject to a red flag order.
Representative O'Neill.
Thank you, Madam Speaker. Well, Representative Richardson, if you would turn to page 11, it says clearly right here that the court shall issue a search warrant for local law enforcement for the agency to take possession of all firearms in the resident's possession as soon as practicable. Now, I don't know how they're supposed to determine who owns what. And how is that person that is in crisis, in a home that still has guns in it, how does that make them any safer if she would yield?
She will yield. Representative Richardson.
Are you asking how would they be safer with the removal of the guns? Can you rephrase the question, please?
Representative O'Neill.
Thank you, Madam Speaker. I'm saying that if all three roommates have got weapons, they all have guns, and law enforcement comes in, first of all, they have to figure out who owns what. But if there are still guns in that home, how is that person any safer with only their own weapons being taken away?
Representative Richardson.
Madam Speaker, Representative O'Neill, in terms of what would happen on a case-by-case basis, with what we know from the research that we've seen, oftentimes when an order has been issued, in most of those cases, people are not necessarily staying in the home. They may be being transported for a 72-hour hold. If there's an underlying crime that has been potentially committed, they may be being arrested. So in terms of how police would respond or how roommates would respond would really be a case-by-case basis.
Representative O'Neill.
Thank you, Madam Speaker. So we don't know. The answer is we don't really know, and I don't see how they're any safer when there are still weapons in the home. And I appreciate the fact that you mentioned the 72-hour hold, because that certainly would be a lot more common sense than what we have in front of us right now. So last thing, members, let's talk just a little bit about the penalty for falsifying information as written in the bill. And I have pointed this out on multiple occasions, so this should come as no surprise. I find it very odd that law enforcement and county attorneys would be charged with a misdemeanor when most likely they were given false information. I find that very curious. Again, that's on page 12. That's 12.2 through 12.5. And I know that this has gone through a whole bunch of changes, and maybe this is just an error in drafting, but it certainly raises some eyebrows. So, Madam Speaker and members, there are multitudes of problems with this bill. And yes, it has made some progress, but it has foundational issues. It has Second Amendment issues. It has Fourth Amendment issues. It has Fifth Amendment issues. And I certainly can't be the only one in the room to see that. Thank you, members.
The member from Sibley, Representative Gruenhagen.
Thank you, Madam Speaker and members. Would Representative Richardson yield for a question?
She will yield. Representative Gruenhagen.
My question is kind of a follow-up on Representative on the previous question on page 12. Is there any liability, Representative Richardson, for a person who falsely makes a claim against another person and starts this process of investigation and ultimately the confiscation of the guns, and then it's found out that it was a false claim? I know Representative O'Neill said that the county attorney and the law enforcement would be guilty of a misdemeanor, but what about the person who brings the accusation? Is there any consequence in the bill? I don't see any.
Representative Richardson.
Thank you, Madam Speaker. In terms of thinking about making statements to the court and doing that under oath, if the penalty for falsifying information under oath would be considered a perjury.
Representative Gruenhagen.
So I'm to assume then if someone makes a false claim against myself or another citizen and it turns out to be false, that they would be charged with perjury? Is that correct, if Representative Richardson would yield?
Representative Richardson.
According to the, thank you, Madam Speaker. According to the law, if you make a false statement under oath, that would be considered perjury, correct?
Representative Gruenhagen.
Oh, thank you, Madam Speaker. Thank you, Representative Richardson. I don't really see that in the bill, but be that as it may, we'll go from there. Members, based on the previous testimony of the previous bill and also the upcoming on this one, I think we've got a lot of laws on the books. Representative Drazkowski, also Representative Detmer, both listed off the 17 or more laws we already have on the books. There's federal laws also. And then on top of that, what we have, and Representative Franson did an excellent job on this, we have our judges, some of them, I'm not going to paint with a broad brush, not enforcing our laws and just turning these people back out onto the street. That's a real problem, members. Doesn't matter what we pass if that's going to be the attitude of our judges. So I do think we need to look at how we can remove or bring into accountability these judges that are not enforcing the laws of the state of Minnesota. I think that would go a long ways to ending some of this criminal gun violence. The other thing, members, I was asked to write an article for the Minnesota Physician this past interim between sessions. And during that time, I co-authored an article. The Minnesota Physician is a periodical that goes to all the medical professionals in the state of Minnesota. I co-authored it with a Dr. Chris Foley. I will just make a few quotes from Dr. Foley's part of the article. Most of you know what my position is on that. And by the way, Dr. Chris Foley has a pretty impressive pedigree. He pioneered in 1979 one of the first integrative medical clinics in the Midwest. He is a former, no, 1995, sorry, members. He is a former instructor of the University of Minnesota Medical School. Dr. Chris Foley is also a former lecturer at the College of Pharmacy of the University of Minnesota. So he and I co-authored an article, and I've asked it to be distributed to all members, on the use of psychotropic drugs on our children in the school and gun violence and the high rate of suicide that we see in our society with our young people. Members, here's a couple of things that he said. He said, there is more than apparent evidence that inappropriate overprescribing of psychotropic drugs for children, often by physicians who have not adequately examined the child. Now, that's not my opinion. That's Dr. Chris Foley's opinion. I'll go on. Many drugs used to manage children's mood and behavior have very little scientific basis or have a very high undesirable risk to benefit ratio. That's Dr. Chris Foley. Then he goes on, he said the evidence, in fact, or just a minute, that there's very little validated evidence that these psychotropic drugs are safe or effective in children. In fact, there is a boxed warning regarding both homicidal and suicidal ideations on several of these drugs that are used on children members. And we had testimony in the ed policy on gun shootings in our schools and gun violence in our schools. And the people who made a presentation, I disagreed with some of their conclusions, but they said that one of the characteristics of school shootings is that the shooter has suicidal and homicidal beliefs. And yet that's one of the consequences of the excessive labeling and drugging of our children in the school. Members, if you, Dr. Foley goes on, a recent expose disclosed that the majority of mass shootings that have been perpetrated by individuals taking these drugs, so the majority of shooters in our schools were on psychotropic drugs, members. We are excessively labeling and drugging our children. France labels and drugs 0.5%. We in this state and nation are between 10 and 12%. And most of it is based on subjective information. Nothing shows up in an x-ray. And we know, members, that if you're on psychotropic drugs past 12 years old, you cannot get into the military without a medical waiver. The Army's loosened up a little bit on that based on the recruiter I've talked to, but the rest of the branches are holding firm. And one of the reasons for that is when you have long-term use of psychotropic drugs on developing children, one of the negative results is violent outbursts of uncontrollable rage. Do you want somebody with a loaded weapon in the military with a violent outburst of uncontrollable rage? You probably don't want that, members. By the way, the use of psychotropic drugs on our children is a $7 billion industry a year, members. $7 billion. There's a lot of money in this. Just a couple more comments. The interesting thing that Dr. Foley brings out is that both in 1994 and in 2017, the Diagnostic and Statistical Manual of Mental Disorders, which is the Bible of psychology, were both adjusted and altered to make it easier to label and drug children. So the people that make up the DSM, it's called, of psychology, which is the Bible of diagnostics in that field, they altered the information in that manual to make it easier to label and drug children. Now they've even come to the point where we are to label and drug our preschool children. Think about that, members. Powerful psychotropic drugs used on 3 and 4 years old. Is that what we stand for in this state and in this legislature? That's child abuse. France labels and drugs 0.5%. We're at 10 to 12% and growing. Members, Dr. Foley goes on to implicate the medical community and say, rather, they're doing the quick, easy labeling and drugging, which brings in money, rather than doing an adequate examination of the child and the reason why the child is having problems. Now that gets to the bottom of the problem for children, not the quick solution of labeling and drugging. Members, if we want to solve a big piece of the shootings in the schools in this nation and even our state, we need to address the psychotropic drug use and abuse of our children. Okay? If you look at Littleton, Colorado, you look at Florida, you look at Sandy Hook, every one of those situations, the shooter was on psychotropic drugs. Do your own research. This is child abuse, and we need to stop it and have a well-vetted study group on why this is being done. Members, oh, by the way, the study about Harvard did a study on the labeling and drugging of children under 5 years old. And what they came up with was it's not a good idea, okay, to take little preschool children and label and drug them. You know, in terms of gun rights, we're passing laws that we think will help or we feel will help. You know, quite frankly, I don't care how you feel about it. What do you think? What do you know? What do you believe? And this is a big problem in our society. Let's address what the real problem is rather than putting these legal band-aids that restrict our Second Amendment rights and do nothing but make law-abiding citizens have more difficulty owning the guns that they have. What you're doing here with this red flag law, you're allowing allegations to start an investigation. And based on the previous testimony, you don't even get the chance to face your accuser. That's one of the founding principles of our country and constitutional law, the right to face your accuser. And it sounds like you don't even have that right in this bill. Members, let's really get down to what the problem is and quit attacking the Constitution and the Second Amendment rights of our citizens. You're not going to stop this. We're only going to make it worse if we continue down this road of the excessive labeling and drugging of our children. Thank you, members. Please think about it and vote this bill down. And let's do what's right and find out what's going on in our schools. Thank you.
The member from Monoman, Representative Green.
Thank you, Madam Speaker. We've listened to a lot of the talk here today, and I know we've listened to some folks tell us that we all took an oath to uphold the Constitution, and we did. And that should be it. I mean, that should be the end of this, but it's not. And so I want to address just a few short things here. I'm not going to talk for a long time because I think that we can pretend we're smarter than we are and talk for hours when it's obvious that most people have made up their mind. But I would like to address some issues that happen in my own district, in particular the counties of Monoman, Becker, and Clearwater, and some of the folks over there. And I talked to them a lot about this. And it was probably 150 years ago now that the government came to them and put their hand, the big government hand on their shoulder and said, "You don't need your weapons. We'll take care of you." And we all know that they surely did take care of them. And what I've asked my folks back home is, how did it work out for you last time when the government did that? And right now, we're seeing the exact same thing here in Minnesota. This body, this House of Representatives in Minnesota, in particular, the Democrat Party, has their great big government hand on the shoulder of the people of Minnesota. And they're saying, you don't need your weapons. You don't need to protect yourself. We'll do it for you. And all through history, whether it's in this country or other countries, it's never worked. It's only led to mass destruction of multiple millions of people by the government. I don't know, I'm not going to sit here and judge you on your motives because I don't know your heart. But I can tell you what, you better look back through history and see how this stuff ends, because it never ends well. And we think we're benevolent here, that because some people elected us, we're smarter than everybody else. We certainly are not, and we're proving it here tonight with these bills that are coming forward. And so I'm going to leave the people of Minnesota with this. We've got two bills here that not only violate our constitutional rights. they work together, because if someone did want to obey the law and they went in to get a permit to purchase a gun and were denied, all they'd have to do is make some snide comment, and all of a sudden, House File 9 kicks in, and somebody's going to be at their door taking their guns. And if this doesn't work to curb crime, we've already heard it from the other side, we'll make corrections to it over time. So should this pass 3, 5, 10 years from now, if it takes that long, and violent crime continues, then the big hand of government's going to be on that shoulder again and say, we need to take some more. We need to come and get some more. We're doing a bad thing here tonight, folks, even bringing these bills forward. So I hope the folks back home, if you're bored enough to be watching these proceedings, when this board lights up, take a picture of it and remember it in November.
The member from Anoka, Representative Scott.
Thank you, Madam Speaker. And members, I wanted to hit on a couple of things. First of all, you have a letter from a former constituent of mine. It's an email that she sent to me. Her name is Joy Orvis. And she was a victim of domestic abuse. And she tells a little bit about her story there. And I underlined some really poignant remarks that she made in this email. And one of the things that I think is really apropos to this particular issue of this particular red flag law is in the bottom of the front page, and it's underlined, it says, as you must know, many women like myself suffer from PTSD, depression, anxiety. And I fear the universal background check law will make it no longer safe for me to own a gun. And I want us to think about victims of domestic violence who have been traumatized by what has happened to them. And not only could they be, when they're having a bad day and PTSD is kicking into them, could someone come back and take their firearm away from them? And maybe that firearm has provided a sense of security to them. And so this bill would leave them feeling very, very vulnerable and very insecure. And I've talked to Chair Mariani a little bit about hearing a bill that I have that has been introduced. And it is a bill that I think would actually help in situations where someone has been had an OFP filed against them, an order for protection. They've had the hearing. A judge has said, yes, we believe that you are a danger to yourself or others. And we have that law right now where it says that that person has to turn over their firearms either to a family member or to law enforcement. But we've found, the media has found, that in 96% of the cases where that firearm is ordered to be turned over, there's no follow-up on it. So my bill would provide for an expedited hearing to make sure that that happens, and if that person is unsafe, then the firearm is taken away. Now that's a bill that actually will save lives. In fact, the news story that broke this statistic that 96% of the time that those cases aren't being followed up on, the news story that broke was because a woman was killed as a result of this. We had the law in place where this OFP, he was found to be a danger to himself or others. He was ordered to turn over his firearm, and that never happened. So here we are, it seems to me, trying to pass bills that, once again, may not be enforced. Or, as Representative Richardson said, we just don't know how it's going to play out on a case-by-case basis. And I don't think that's secure enough for the public, law-abiding citizens. That's not much of a guarantee. Well, we'll just wait and see how it plays out. And I want us to think long and hard about this issue of restricting someone's civil rights to due process. And think of any other situation where someone, by virtue of just an accusation, and that's what this starts with, could have their civil right to due process taken away from them. And I think we can all imagine, maybe it's a person that's simply a minority and someone's accusing them of some action. And would we ever, ever consider taking away their right to due process? So members, I think this bill may make you feel good, but in the end, I do not think that it is going to be effective, and I think that it will only punish those that are law-abiding citizens once again. Thank you. Please vote no.
The member from Clearwater, Representative Grossel.
Thank you, Madam Speaker. Members, again, here's another one. Here's another one of those bills that should have found its way to the circular file immediately. Again, another piece of garbage as far as I'm concerned, because it violates some very, very important amendment rights that we all have, and that this legislation just tramples under its feet, under the feet of whatever you want to call it. It tramples all of our rights, our Second Amendment right, our Fourth Amendment right, and our Fifth Amendment right. Our Second Amendment to the right to keep and bear arms, our Fourth Amendment right to be secure in our properties and our persons and our papers and effects from unlawful search and seizure, and our Fifth Amendment right to due process, innocent until proven guilty. To even bring something like this forward in the Minnesota State Legislature, it's outrageous and shameful. We took oaths. We took oaths to uphold the Constitution of the United States. And yet you want to destroy it. You want to tear it apart. You want to start to chip away out of it until you start to disassemble the whole thing. That's the wrong answer. Look at other countries that have taken their rights away from their people. It's a mess. As I said, this bill violation of constitutional rights, seizure of property without warrant, violation of civil rights. There's no other constitutional right that is treated with such disregard. This bill allows guns to be seized under the preponderance of evidence. Basically, more likely than not. Based on claims from a reporting party, and I have to stop there because I wrote a few search warrants in my day, helped execute a few search warrants in my day. A gang, guns, a violent crime task force, narcotics, we had to go and hit some pretty awful places. As a SWAT team member as well. You knew that you were going to execute a warrant and invade someone's home. So you better have your ducks in a row. And I look at this legislation, this piece of legislation, and it takes all of that stuff and throws it out the window. You are not secure in your homes if this stuff passes. Any one of you, any one of us, you will not be secure. Because as peace officers, we can be directed. Go take it. They didn't answer that petition that we sent them 24 hours ago. Go take their guns. I can guarantee you this. There's a letter here from the Chiefs Association again, and I'll dispute with them because they say they have the support. This one does not. I speak to all the law enforcement officers in my area, sheriffs, chiefs included. They will not execute a warrant on this kind of thing. They'll do it the right way, but not with this piece of garbage, because that's what it is. I'm just being honest with you. This is just a extreme violation if it passes into law, which, you know, thank goodness for the Senate, it will not. You might get your little happy time here in the House. That's as far as it's going. I'll guarantee you that. We have all the tools in place, you know, and I hear people saying this will help save people in crisis. You know, come on. Be honest with what you're trying to do with this. You're not going to help anybody with this. If you want to help people in mental health crisis, then let's talk about that. Let's do that. And I know the people back home in Bemidji, in Beltrami County, we're working on getting some help for people that are having mental crisis and mental illness. It's not through this. And I know there's other places in the state that are working on helping people who are struggling with mental issues. There are a very, 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 very small percentage of people who have mental health issues that are dangerous. So leave those people alone, for crying out loud. Again, you know, we all took an oath. Some of us take it a little more serious than others. I can see that now. You'll have your little happy time, I said. You'll get this thing passed off the House floor like you did the other one. But the people in rural Minnesota, the law enforcement in rural Minnesota, and I bet you if you ask the law enforcement on the ground here in the metro area, they don't want it either. Because you're not only going to put your law enforcement officers in undue danger, you're going to put the public in undue danger. Representative Richardson, nothing personal, but you need to throw this thing away. Thank you, Madam Speaker.
The member from Hennepin, Representative Hertas.
Thank you, Madam Speaker. And members, I would like to talk about regular protections for order and this red flag law. And Madam Speaker, I was wondering if Representative Pinto might be able to yield for some questions.
He will yield. Representative Hertas.
Thank you, Madam Speaker. Representative Pinto, I think I am correct in remembering that you, in private practice, were a county prosecutor. Is that correct?
Representative Pinto.
Thank you, Madam Speaker. Representative Hertas, I continue to serve as a felony-level prosecutor. I specialize in gender violence cases, but certainly have handled the wide range, and I continue to serve in that role outside the legislature.
Representative Hertas.
Thank you, Madam Speaker. And if Representative Pinto would continue to yield, I just have a few questions about protection orders.
He will yield. Representative Hertas.
Thank you, Madam Speaker. Representative Pinto, it's my understanding with regard to protections orders that the standard of proof to obtain such an order is quite a bit different than that in criminal proceedings where you have to have a preponderance of evidence. Is that correct?
Representative Pinto.
Thank you, Madam Speaker. Representative Hertas, yes, I believe that's correct. I should note that those are actually civil orders, so I'm more involved in the enforcement of the order once it's issued. But my understanding is that, yeah, that the standard for the issuance of those orders certainly is much less than in a criminal case.
And Madam Speaker,
Representative Hertas.
Thank you. And if he would continue.
He will yield. Representative Hertas.
Thank you, Madam Speaker. Representative Pinto, in your experience in prosecuting criminal law and maybe even these orders for protection, do you have any idea of what the percentage of orders that are actually granted when a petitioner requests one? Is it relatively high, or is it low, or is it kind of a lengthy process to get it? Can you talk a little bit about the process in that regard?
Representative Pinto.
Thank you, Madam Speaker. Thank you, Representative Hertas. So again, I don't handle those orders, the issuance of those orders, so I can't really comment about the percentages and things. I do have a sense of the process, and I should probably note that the process here is quite similar and very much modeled on that. The person brings evidence, there's a sworn affidavit, there is a hearing, there is an ex parte hearing that's allowed for, as in this bill as well, if there's a great urgency, but then the person is given notice, the chance to respond, et cetera. The major difference here is that only law enforcement and prosecution can bring one of these petitions, unlike in the case of an order of protection, harassment, restraining order, when a private citizen can. Thank you.
Representative Hertaus.
Thank you, Madam Speaker. And Representative Pinto, thank you for helping me with that a little bit. And I won't indulge you in any more questions about the process. It's my understanding that, at least in Minnesota, that when somebody requests a order for protection, that it's a little bit higher than 90% of them are granted. And with that in mind, in reviewing the process, I find that a hearing is actually ordered, and an order is given to the court to schedule quickly a hearing so that the respondent may show up in court. In some circumstances, it may be even an ex parte hearing, which again has been previously explained, that the defendant or the respondent in that case would not even be present. So in orders of protection, I also note that it's possible to get an order from the court to have the respondent, even the ex parte respondent, to have guns removed from their possession. And in that process, again, the hearing is happening first, and then the respondent has a period of time at least to defend himself or present another side of the case. And if the determination is made in that instance, then the respondent has three options what to do with the guns. He can turn them over to law enforcement, he can turn them over to a federal dealer, or he can turn them over to a family member that does not reside with him. Members, it appears that in this law, the court shall issue an ex parte emergency order prohibiting the respondent from possessing firearms for the duration of the order. The court under this law has that authority. It also goes on to say that the order shall inform the respondent that the respondent is prohibited from possessing firearms and shall issue a transfer order under the sections of law. And that must be complied with within 24 hours. And he doesn't get an opportunity to defend it. It's just the court makes that decision to do it. Madam Speaker, would the author yield for a question?
She will yield. Representative Hertaus.
Thank you, Madam Speaker. Representative, I noticed here on lines 10.4 that the transfer ordered by the court may be permanent or temporary. It's really not clear in that language if that's discretionary on the part of the respondent. Do you know what the answer to that is? Further on down, it explains what might happen under those circumstances, but it really doesn't say if the respondent has the discretion to surrender firearms in a permanent or a temporary way.
Representative Richardson.
Thank you, Madam Speaker. Excuse me. So to your question, and when you're thinking about the orders that the courts could give, they'd be temporary orders. They could be for 6 months, for up to 2 years. If a respondent decided to not contest a request for an order that had been put in and just wanted to hand over their guns to law enforcement, they would be allowed to do that under the bill.
Representative Hertaus.
Thank you, Madam Speaker, and thank you for explaining that. Well, it doesn't sound like there's much requirement of full disclosure to the respondent here. Could very well unknowingly and think that they're cooperating with the order and surrender possession of their property only to find that they may be destroyed. And so that's of great concern. I guess, members, in the end, it's pretty paramount to understand that this law is intended, obviously, to intervene where somebody thinks somebody's a threat to others. Certainly under the current law, at least there's due process in a protection order or a request for protection under the existing law where there is a hearing and the person gets to respond. But now we're creating a different pathway where that person is denied that right to defend themselves and to offer a counterpoint to the accusations. We already know that the court errs in favor of the petitioner more than 90% of the time. So you can be assured that anybody subject to a red flag law is going to be subjected at least 90% of the time or more to this situation of having their guns confiscated from them for an unknown period of time. And that's going to be up to the determination of the court. Secondly, it also, I thought was quite odd that the court may even charge the respondent a reasonable processing fee and fee for storage of guns if it is temporary in nature. So, as I mentioned before with the other bill, members, this again violates due process. It's really not constitutional. And please vote red on this bill. Thank you.
The member from Isanti, Representative Johnson.
Madam Chair, members, I don't know what to say about this offhand. I have a lot of problems with this. Would Representative Christensen yield for a question? Richardson.
She will yield. Representative Johnson.
Representative Richardson, I'm trying to figure this out on lines 9.31 through the first part of 10.1, except as provided in paragraph B upon issuance of the extreme risk protection order. What I'm wondering is that issuance, is that when the judge signs it or when it's served on the person?
Representative Richardson.
Madam Speaker, are you asking when the 24-hour period would commence?
Representative Johnson.
Madam Speaker, Representative Christensen, it doesn't clarify. I'm trying to get clarification. Is this when the judge signs it? Because that's when the orders are issued, is once the judge signs them.
Representative Johnson, Representative Richardson is the bill author. Representative, and are you asking her to yield again?
Yes, I am, please.
Okay. Representative Richardson.
So when the judge would make the order is when the clock would start ticking.
Representative Johnson.
Representative Richardson, thank you. Would Representative Novotny yield for a question?
He will yield. Representative Johnson.
Representative Novotny, you, like myself, we've served many papers, from domestic abuse orders, search warrants, many different types of papers. Now, once the judge signs a paper that goes to the civil process area, from the time the judge signs a paper, on average, how long does it take to prepare a paper to be served?
Representative Novotny.
Thank you, Speaker, and Representative Johnson. There's so many variables involved in that situation. Where the person is, are they in the same county, getting the information entered into the statewide system so it is enforceable, and does the person even, are we able to locate the person? If they were at work, if they're out of the area, these are all factors that would make the timetable expand. It's also compounded by this being an ex parte order, the person not knowing it's coming and not knowing where they're at or being able to contact them.
Representative Johnson.
Madam Chair, members, that's one of the problems with this bill. You have 24 hours from the time the judge serves it to have those firearms turned in. Generally, it's 24 to 48 hours before the papers are even ready to be served. Now he's out of compliance on this order already, and we haven't had an opportunity to even serve the paper. And the serious part is, if we do happen to get them right away, if we get within 12 hours, He can decide, it doesn't say law enforcement shall remove the firearms, which they don't want to do, but the person being served has another, let's say, 12 hours. There's a person in crisis with firearms, that you're leaving him with firearms. Now he's even in more crisis because they're taking their firearms. The way this bill is written is going to make it more dangerous. It's a poorly thought out, poorly crafted bill. Now, dealing with that person in crisis, this bill does absolutely nothing. It doesn't say to assist that person in crisis, get them the help they need. No, it's just say, hey, we're here, we're going to take your firearms. We're going to leave you here with the knives, the gun, or the knives and everything else, the chemicals, the pills in the medicine cabinet. Oh, by the way, there's probably more people killed with knives than rifles. In fact, I know there is. But we need, instead of doing something like this, we need to help those that are in crisis. We have the tools already on the laws. We have the 72-hour hold that will get them in the door to let the people who can deal with it make sure that the person is not in crisis and work with them. This is an unneeded bill that violates constitutional rights, but we have ways to help those people within our Constitution, and that's what we should be doing, is the things we have in place already.
The member from Olmsted, Representative Quam.
Thank you, Madam Speaker and members. Do no harm. At the core of this bill is mental health. But let's face it, that's at the core of this bill. For years, my wife was a first responder. 1 o'clock, 2 o'clock in the morning, the pager would go off, and I would hear part of it as she was running out the door. She saw too many tragedies, too many horrible things that I'm glad that I didn't have to see. And frankly, the majority of the suicides she saw and encountered and responded to did not involve guns. Knives, drugs, etc. A lot of the violence out there might be relational to mental health and personal issues, but this bill doesn't solve that. And if we delay addressing the core problem, I think we're doing harm. I'd ask both sides of the aisle to come together, and instead of working on this bill, to work on a mental health bill to actually help the people. Because she had occurrences where the drugs were, or not the drugs, but the guns were taken away by the other family members. They weren't around. They were concerned, and they ended up committing suicide in a different fashion. Now, you may have noticed a lot of our amendments that we offered said that if law enforcement comes up and is told this person is a danger to themselves or others, we have, let's do the 72-hour hold. That has been shown to make a difference, to save lives, to get help to the people so that they don't hurt themselves. They have help their lives get better and also prevent them from hurting others. That's the core thing we should be working on. Do no harm. And I think this bill does do some harm because it will generate some number of dangerous situations. If somebody is woken up from their sleep by somebody breaking in the front door and they've got a gun handy bad things are going to happen. Wouldn't it be so much better that the hours before, days before, when somebody brings up an issue, we get real help? We don't sort of ignore a core principle of due process. We don't have an issue with an arguable problem with a constitutional right. You know, some people feel strongly, others might not. But let's address the real problem behind the tragedies this bill is supposedly going to fix, but doesn't. So instead of spending time here where I think we cause harm, let's come together and work on another bill that addresses the underlying problem and saves lives. Thank you.
The member from Roseau, Representative Fabian.
Thank you, Madam Speaker. Members, I view House File 9 as a tremendous infringement on our Second Amendment rights and other amendments within the Constitution. And the thing that we're doing here this evening, the bill that's being brought forward, has been brought forward in some other states. And the actions of some elected officials in other states has really caused a grassroots movement to start. And I think it started in Virginia, and it's grown to other states, and it's now here in Roseau. And what's happening is that counties are passing resolutions. It actually started, I believe, with the sheriffs in Virginia as a result of what's going on in the state of Virginia with regards to red flag laws and others, and those that they feel are unconstitutional and really infringing on the rights enumerated in the Constitution for law-abiding gun owners. One of the things that happened in Roseau in January, I was invited by a good friend to go to a county commissioner meeting and talk to them about the Second Amendment and encourage the county commissioners in Roseau County to take a stand to protect the rights of law-abiding gun owners in Roseau County. They formed a committee. They took a look at it, and in February, they passed a resolution, the first county in the state to be what they considered a Second Amendment dedicated county. Not long after that, I had an opportunity to talk to the commissioners in Marshall County, and they asked me some questions, and I encouraged them to take a thoughtful look at what they were doing or what they could do to protect the Second Amendment rights of the people in Marshall County. So at their next meeting, they passed a resolution as well, stating their strong desire and their strong intention to protect the Second Amendment rights of the people of Marshall County. I'm not going to read it all, members, but they feel that some of these things are unconstitutional. And in their resolution, the county commissioners state that they expressed its intent to uphold and protect the Second Amendment rights of the citizens of Marshall County, and that the Marshall County Board of Commissioners hereby declares Marshall County a Second Amendment protection county, and that the Marshall County Board of Commissioners hereby declares its intent to oppose any infringement on the rights of law-abiding citizens to keep and bear arms, and that the Marshall County Board of Commissioners will refuse to appropriate any Marshall County resources to enforce any mandate, law, policy, order, or any other directive which infringes on the right of law-abiding citizens to keep and bear arms, and that the Marshall County Board of Commissioners will use any legal means, including and without limitation, court action to prevent the Second Amendment rights of citizens, to protect, the Second Amendment rights of citizens of Marshall County. Unanimous vote. Unanimous vote in Roseau County. The Pennington County Commissioners are considering that at this time. Kitson County Commissioners are considering it. I believe Clearwater County passed a resolution recently. And I've also heard some of the comments made about the actions being taken by county commissioners. And I can tell you that the people in my part of the state take great offense. And what some of those comments have done, it's dividing a further wedge between the people who are pursuing red flag law, House File 9, and the resolve of law-abiding, Second Amendment-loving gun owners in much of rural Minnesota. It's hardening the resolve. This bill, I don't believe, is going to do anything to protect. And when I talk to law enforcement, and here we got these letters again for this bill too, when I talk to my law enforcement officials, they are strongly opposed to this type of law. And I've even had the occasion to talk to boots on the ground law enforcement people. They've been around this complex for the last couple of days, and they too tell me that they are opposed to the red flag law because it's viewed as being an infringement on our Second Amendment rights. Members, I encourage a red vote on House File 9, and let's together stand to protect the Second Amendment rights of Minnesotans. Thank you.
The member from Candy Ojai, Representative Miller.
Thank you, Madam Speaker. Members, this is a bad bill. I think you've heard many reasons why, and you know, the people of my district, what they tell me often is we want Republicans and Democrats to find things that we can do that affect change and for the good of the state of Minnesota. We want them to work together. We want them to find compromise. We want them to find common ground. I don't know about your districts, but there is no common ground on this bill, but here we are tonight anyway. I did want to make one point. I heard a lot in the previous bill, the great respect for law enforcement's opinion on that bill. And I think maybe we should listen to them on this one as well. Sort of the benefits of people able to watch us here, stay tuned, and then communicate with us. I actually had one of my sheriffs text me while this bill was going on, and here's what he said. He said, maybe the House author would accept an amendment to their red flag proposal. House reps will be the ones responsible for going into the homes in their districts and collecting the guns. Think they might change their minds? Here's the important part, okay? I know I'm not really interested. Members, my sheriffs and your sheriffs are responsible not only for their own lives, but the lives of all of their deputies. I was wondering if Representative Richardson would yield to a couple questions.
She will yield. Representative Miller.
Thank you, Madam Chair. Representative Richardson, if you could answer me, how many county sheriffs have you spoken with concerning this bill?
Representative Richardson.
Madam Speaker, Representative, we worked with the county, the Sheriff's Association, and so we worked with them on putting together the bill and actually made several changes to the bill based upon those conversations.
Representative Miller.
Well, Madam Speaker and Representative Richardson, I appreciate that answer, but you didn't answer my question. Because the Sheriff's Association, granted, they have a representative force here at the Capitol, but those aren't the individuals that are necessarily walking up to the door and pounding on that door, not knowing what's behind that door. So I'll ask it one more time. Madam Speaker and Representative Richardson, how many sheriffs in the state have you talked to concerning this bill, particularly about their responsibility in this bill?
Representative Miller, are you asking Representative Richardson to yield?
Sorry, Madam Speaker, I'm asking Representative.
She will yield. Representative Richardson.
Madam Speaker, Representative, what I talked with the sheriffs about and other law enforcement about as this bill was being developed was a number of the best practices that have been developed in other states that have enacted red flag laws. And one of the most important learnings that I had was looking at the way that this law has been enacted in California, specifically in San Diego. And they have relied upon a de-escalation approach as they've been working to serve these orders. And one of the issues that became very clear from their approach, they're not going and knocking on people's doors in the middle of the night to serve orders. They're actually working to connect with people in the community. Maybe it's through a traffic stop. Maybe it's when someone is taking their garbage out and they are using de-escalation techniques to have conversations. And based upon that, they also shared that within 98% of the cases that they had worked with individuals, that they willingly transferred their guns to law enforcement. So those are the types of conversations that I've been having, and those are the types of conversations I've shared with law enforcement.
Representative Miller.
Thank you, Madam Speaker. Well, I won't continue to ask the questions about law enforcement officers. I had questions about police chiefs and police officers as well. But it's apparent to me from what you have said that you haven't talked with these people. And I appreciate the fact, Representative Richardson, that you've talked to people in other states about the processes by which they do this. But as the cliche goes, that doesn't feed the bulldog when you're talking about someone that has to approach someone who knowingly has weapons, and the information is limited on that. And I can tell you that I have talked to my sheriffs, and I've talked to sheriffs in other counties, talked to police officers, because in fairness, I need to know what it is that they think. They're the ones that are on the ground doing the bidding of this legislature if this were to be signed into law. They have to act on what it is that we say here. And they have to act in it to where it's a life or death situation, or for the life or death situation of the people that they are responsible for. And I have yet to hear a sheriff or a police officer or a police chief or anyone in law enforcement tell me that they really want to do this. I've only heard the opposite. Now, I could probably go around room to room and to all 133 other people, or 130 that are in this room at this time, and ask them if they talk to their sheriffs. And I'm sure that maybe some have. I have a hunch that a lot of the people that are maybe a little bit more metro in this room probably haven't talked to their sheriffs about this. I think it's a fair assumption, but I won't ask each one to take a roll call on this, okay? I can tell you that in rural Minnesota, okay, where there's lots of open space, there's lots of opportunities for things to go wrong in that open space. I'm not talking about just going out in the dark of night and doing this. I'm talking about driving up onto a farm site, not knowing what's there with multiple buildings, and them getting out with the knowledge of the person on the other side somewhere, could be any one of those buildings, could be anywhere, with the knowledge that they have weapons that are going to be confiscated by law enforcement. This is a volatile situation, members. Now, if we were to have a bill here that was really close to kind of addressing some issues and really close to getting things right, we could probably tweak it, and we could talk about being trained on the proper ways to disarm a person without any sort of hostility being enacted and stuff like that. But I go back to my original statement. This bill isn't even close to not only achieving the goals that it's intended to do, but it's not even close to being a good law in many different ways that the people of Minnesota expect. This is very disturbing that we're doing this, members. This bill has been very clearly out for the last couple of years, lots of talk here in other states. There's mentions about presidential candidate Bloomberg being funding behind this, moms demanding action and stuff like that. We all kind of know that that's really what's happening out there, and that's what's happening here. And yet we are driving a bill that, in my opinion, is really driven to make sure that we count the votes of how people voted on this, not really enacting good law in the state of Minnesota. We're doing all this at the expense of the threat of our peace officers' own lives. If there is no other reason to vote no for this, which there are multiple reasons, if there is no other reason, it's that we need to respect those people who are putting their lives on the line for us, and they're saying, please don't do this, Members ask for a no vote.
The member from Ramsey, Representative Pinto.
Thank you, Madam Speaker. Members, if we're concerned about the people who these orders would be enforced against, maybe that's a reason that we are concerned about them, in fact, having firearms. Members, Representative Miller, you made the point that your sheriff is perhaps not interested or is concerned about what would happen in enforcing an order. Well, then your sheriff does not have to bring the petition for the order in the first place. This is a tool for law enforcement prosecutors. They're the only ones who can bring this. If they believe that someone is such a danger that that person should not have access to firearms, then they have this as an option. That is why you said that you're not aware of police chiefs who are in favor. Look on your desk. This is a letter from the Minnesota Chiefs of Police Association calling for the adoption of House File 9, saying that we need this. And no wonder, again, that they would say that, because it gives them the option. If the person is dangerous enough, they can do it. If the person is dangerous enough that they're concerned for their own safety, then I would think they might want to do it. But the good thing is this gives them the option. And as Representative Richardson says, they can figure out how to enforce the order in a situation that will work best for them. But they get to decide whether to bring the petition in the first place. So in that way, Representative Miller, this is something that empowers law enforcement in a situation where we all have reason to be concerned about how someone is going to be acting and what the situation is. There's been this concern expressed about violating constitutional rights. Members, this is in use around the country. If there were concerns with this, with criminal background checks regarding their constitutionality, then a court case could be brought and they would presumably be overturned. They have not been. This is entirely consistent with with constitutional rights, because this is a situation where people have demonstrated through their actions that they, for a temporary period of time, should not be in possession of firearms. And we know that there are so many situations when this has arisen. In other states, they have acted when there have been tragedies. In the Parkland situation in Florida, afterward, law enforcement said, we knew that there were concerns. We did not have the legal mechanism that we could use to act. And so after the Parkland shooting, the Florida legislature, controlled by the Republican Party, the Florida governor, a Republican, took steps and said, we need to act, and they adopted an extreme risk protection order, a red flag law. So the real movement in this country, members, has been the people who have been affected by each of these shootings, the people who are recognizing time after time after time, Columbine, Sutherland Springs, Morgantown, so many different communities, and have recognized that we need to act. So, members, I just want to note this. In 2012, I guess it was, December 2012, my son was in first grade, the same time as those Newtown students, those children, were in first grade as well. And I really thought that after that shooting that things would finally change, that those first graders being shot would finally make a difference. It is 8 years later, and we've had tragedy after tragedy after tragedy. And in different states, each of those tragedies has caused legislators, caused policymakers to act. Members, there is no need to act any longer. We need to move on criminal background checks as we did in the last bill. We need to move on extreme risk protection orders. We need to take steps to take guns out of the hands of people who have demonstrated through their actions, have proven that they are dangerous. It's time for us to act. Thank you, Madam Speaker.
The member from Hennepin, Representative Katiza-Watun.
Thank you, Madam Chair. We've heard a lot tonight about how neither of these bills are going to do anything to keep Minnesotans safe. And a story came to my mind earlier this evening. I wasn't going to share it, but I chose to. If you haven't heard the story about the little boy who's running up and down the beach, picking all the starfish up off the sand and throwing them back into the water. And I don't know if it's his grandfather or just another gentleman who happens to be walking down the beach at the same time. The old man says to him, "Look at all these starfish. You can't possibly save every one. Why are you wasting your time? What are you doing?" And the little boy just keeps running up and down the beach, picking up starfish after starfish, and he says, well, made a difference for that one, and it made a difference for that one. If these bills that we're passing tonight save just one Minnesotan's life, isn't our time here worth it? I think so. Thank you, Madam Speaker.
The member from Dakota, the author of the bill, Representative Richardson.
Madam Speaker, members, the only goal of this bill is to save people's lives. We use ex parte orders for child removal. We use ex parte orders for victims of domestic violence for OFPs. And I will also remind members that Connecticut passed a red flag bill 20 years ago, and that bill has been upheld as constitutional. Florida also passed a red flag law just recently, and in 2019, that law was also upheld as constitutional. I want to spend a moment just to raise an issue about mental health, because there's tremendous stigma around mental health. And I want to leave members with the understanding that individuals with a mental health diagnosis, they're much more likely to be a victim than they are to be a perpetrator. Red flag laws have saved lives. I had the opportunity to speak with a city attorney and a sheriff and a police officer in San Diego, and they shared the stories of the families that had been impacted by this law, including individuals who were at risk of self-harm, who had come back to them after a cooling off period to say thank you. Thank you for saving my life. We know that this red flag law is not going to solve every issue, but it's a tool. It's a tool that law enforcement can use along with other tools within our system, including the 72-hour hold, in order to support our communities to be safer. Members, we have an opportunity today. We have an opportunity to be proactive and to pass a law to keep Minnesotans safe. 20 years ago, when Connecticut passed this law, they passed it after tragedy. When Indiana passed their red flag law, it was after tragedy. Florida was after tragedy. Let's not wait for another tragedy. Let's stand up for Minnesotans today. I ask for a green vote.
The clerk will take the roll. The clerk will close the roll. There being 68 ayes and 62 nays, the bill is passed and its title agreed to.